Hello, YouTube. I'm Vince White. I am an employment attorney, and we are answering publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. It's late. Sorry. Okay, we have a question here from YouTube user Dominique Woods, who asked us, what do you do if you have evidence of the employer lies, that if you have evidence that the employer lied and you try to have your legal representative acknowledge it, but then he chooses not to represent you due to the amount we could have won, which would not have actually covered his services. Although it was originally supposed to be that there would be no payment unless we won. Okay, so it's going to depend on the retainer agreement, and I don't know what your retainer agreement says. But a lot of firms will have retainer agreements that basically say, hey, listen, if new evidence comes to light that the case isn't very good or the case valuation is very low, we can walk. And I don't know the legality of that in your jurisdiction where you are. You might want to check with local attorneys. You could check with the bar association where you are. Check it out. I don't know what that language, if it is in your retainer agreement, means where you are. I don't even know necessarily. There might be parts of the country where that language isn't even required in your retainer agreement. And if that language is in your retainer and it is going to work where you are, or if it's not required where you are, then this attorney might be able to just walk away from you scot-free. I don't know. But also, I think you're really focusing on some interesting things here. Like, you're saying the person lied. The employer lied. That's good. Lies are opportunities for your case, but that doesn't mean your case is necessarily provable. Like, most employers lie. There's lies in most of these cases. The lie in and of itself doesn't mean your case is definitely going to win, and it doesn't mean your case is of high value. We have a playlist on this channel of how to calculate the value of your case. I'm not saying I agree with your attorney. I don't know anything about your case. I'm just saying you might want to calculate the damage to your case to see what the valuation would be, right? Like if I go to work tomorrow and my boss says, Vince, that dumb pink Irish face of yours, I can't stand it. You get a promotion. Do I have a discrimination case? I do. Potentially. What's the valuation? $0? Maybe a few because I felt bad, right? Like, it's not a very valuable case. I'm not saying that's what happened to you. I'm not trying to compare this kind of silly example to what you're experiencing. I have no idea what you experienced. But what I am saying is you may want to look at the damage calculation playlist and see how you would apply those concepts to your damages. Because it's entirely possible your attorney's just wrong, right? Your attorney might be talking nonsense and might have been trying to flip your case for silly money, for nothing, and got mad when you wouldn't let him or her do that and walked away because they didn't know how to actually run the case, right? So I guess what I would say to you is the move forward here is probably you calculate the damages in your case. You get a feel for the strengths of your case, which may or may not include that lie. That lie might be part of what makes your case strong. But I'm assuming if you're watching this channel, you're dealing with either workplace discrimination or workplace sexual harassment. A lie is not in and of itself going to be enough most of the time to prove workplace discrimination or workplace sexual harassment. You have to prove the other elements, right? So look at the strength of your case. Look at what you can prove in terms of the claims you have. And if it's a different kind of claim, look at the elements of that claim, whatever that might be. And then what I would say to you is once you have a really good feel of the damages and the strength of your case on your own without this attorney, who you don't have to trust, you don't have to take that attorney's word for it, I would look at our other playlist on how to present your case to employment attorneys. And I would really work on like a good elevator pitch, like a good opening 5 minutes on how to present your case to attorneys. And hit high points like, here's why my case is strong. Here's what we can prove. Here's how you know we can prove it. We've got this line in writing. We've got these elements of the discrimination claim in writing or the sexual harassment claim or whatever it is. And here's how we can prove all of that. And I did a damage calculation. And listen, you're going to do your own, but mine came to $1 million or whatever it is, right? And listen, I know that number sounds crazy, but like, here's how I reached that number. And like, maybe you want to look at it too, because I think this case could actually be valuable and I think it's strong. And that fresh attorney might get really excited and want to represent you. And hopefully this other attorney who's walking away from you is giving up his or her contingent interest in your case. So at least you can hire a new attorney and they can take their contingent interest and not have to, fight with this other old attorney about money for work he didn't really do, right? He didn't put up a result for you. So I guess that's how I would approach this, Dominique. I hope this is helpful. I think some of my suggestions might have sounded patronizing. I did not mean them to be. I'm purely basing my recommendations off what you're saying here. Because you're like, there's a lie! There's a lie! That lie might or might not be valuable to you. Or it might be kind of valuable, or the most valuable thing in the world. We don't know. But the lie, which you're kind of leading with here, doesn't really have a ton to do, potentially, with the valuation of your claims. Right? I don't know if your attorney is correct or not. I'm not saying it is. I'm not saying they are or they aren't. I'm just saying do your own calculation. Follow the playlist. Go through the steps. Get a feel for the value of your claims. And then get a feel for the strength of your claims, which are two separate things. And then if the strength is good and the valuation is good and you still want to pursue this, great. Pitch it to more attorneys. Get better and newer counsel who will do what you want and fight this case the way you want to fight it. That is really what my takeaway here. And I hope that is what's coming across, and not me being like, I'm not saying that you don't know what you're talking about. I'm not saying that. What I'm saying is, hey, from what you're saying here in 2 lines, I can't get a really good feel for what you're thinking about in terms of this case. So I'm suggesting an array of things that might be helpful to you because I don't know where your mind's at and I don't know anything about the case. So I'm giving general answers, suggestions that I would give to almost anybody in your position. I hope that makes sense. If it does make sense, if it does help you, like, subscribe, comment down below. If it doesn't, I will check the comments down below. Tell me how I failed you. I will try to make you a follow-up video that gives a better job. And remember, almost everybody works. A lot of people don't win.